the intro.
Yeah.
Hey, thanks everybody for attending. This is a bi-weekly webinar that RealTrade hosts with New Path Title. I'm Ryan Poole. I'm a fellow agent, been doing this for over 20 years. I'm also the founder of RealTrade, which is online marketplace and social media platform for real estate. I cover everything Zillow meets LinkedIn, but only for real estate, but a different business model than Zillow. Nice thing about us is we don't charge for leads and it's free for agents to sign up. So I ask you to sign up. It's free. And imagine that you can get direct leads from your own listings. So check that out. And of course, my co-host, Jim, one of the quintessential entrepreneurs. Not only is he a real estate attorney with his own real estate firm that specializes in real estate, he also is the founder of New Path Title and an awesome closing software, Title Leap, which I love for all my closings. So Jim, why don't you go ahead and take us away?
Thanks, Ryan. I appreciate the intro. One thing real quick, we got a holiday appreciation party for everybody, December 5th at 7 p.m. at Sushi Joe on the second floor. Anybody wants to come by for a complimentary cocktail and some hors d'oeuvres, we'd love to have you. We've updated our closing cost calculator. So now our closing cost calculator, as far as I can tell, is an industry first with all the offsets for buyers and sellers compensations and credits and all the little things that make up today's transactions so intricate. You can actually put in seller concessions and buyer agent closing cost, buyer agent commissions, and give your clients an accurate picture of what financially is going on, because that's got to be confusing to them. My goal today is to tell you guys what you won't hear anyplace else. You can get all the forums content from the floor to bar on YouTube, but I want to go into the things that you don't hear. It's a little controversial. I'm going out on a limb, but I enjoy what I do. There are no bad questions. If you can leave your cameras on, I can see your reactions. And anybody, if we have a small group and we all stay tight, we can chime in at any point during the show, as long as we don't get too far off track. There'll be a question and answer session at the end, and you can always text me 24/7 by going to New Path Title and send me any questions you've got on my transaction or anybody else's transaction. And that's it for
Awesome.
intros.
Yeah, I'm going to put a couple links to New Path Title. You can, and to RealTrade too in the chat, so you can check those out too as we go.
Without further ado, can you see my screen, Ryan, with the outline?
Yeah, I can.
All right. So here's the topic for today. Sellers' disclosures. When sellers and agents don't have to tell what they know and when they do. We'll explore the 2 new disclosure laws on condos, the easy disclosure rule you had no idea existed in the contract, and disclosure examples that'll stick with you for a lifetime. And then we're also going to take a step back into SITS or NAR. It's going to take a little longer than I want, but it's worth diving into so that we all understand the issues and we can all make our own decisions. Here is the question that John was talking about before we got into the show. So with the last show, Liz, I don't know if I see her in here today. I do not see her in here today. Liz had a great question, and she said, what can agents do if the condo association won't answer the realtor's request for information on milestone inspections and related topics? So last show we were talking about milestone inspections, and I gave you guys a checklist of everything that you should be getting from the association so you can properly educate your buyers and sellers. Liz said, what do you do if they don't cooperate? And the first thing I said was get the seller involved, remind the seller if they have this issue with the future, they'll have this issue with this buyer, they're going to have this issue with future buyers. So you might as well get it out of the way now and get involved. The other thing I said was you can engage an attorney. The thing I failed to mention was, and it was the easy answer, remind the association they are bound by the rules in the governance form. So here is the governance form. This is one of the documents that everybody's supposed to provide their clients during the transaction. And there's a whole bunch of general rules in here about condominium governance. And so I pointed out a few of the rules in the outline I gave you. In the generally section number 7, in the meetings and notices section number 6, and in the associations finances section number 3 and 4. These are all rules that you can send to the condominium association and say, hey, these are the rules that bind you guys. Do I think they're going to roll over and surrender right after you send in the rules? No, but I've seen it absolutely help, and I've seen it absolutely get agents to their goals. And a lot of times people don't know the rules that bind them on both sides of the board. So if you show them the rules and explain to them this is by statute, some of these smaller associations absolutely fall in line.
Hey Jim, what happens when like I'm doing one alone right now, the association's attorney is telling them do not answer the condo questionnaire. No, no way, no how. And most lenders won't lend in there unless that questionnaire I have a lender that will do it, but most lenders won't lend in there unless that questionnaire is completed.
Oh, well, absolutely. So that's a business problem for a seller. If the association's position is we're not going to answer condo questionnaires, now you only have cash buyers. That hurts your seller dramatically. Who is just out of curiosity, who's the attorney who's given that advice? Well,
I
let's not, I mean, I would love to find out more as to why that position is. So if you want to respond to them and say, hey, I have an attorney I work closely with, he wants to know why you guys, why your position is that you don't want to answer these things. I'd love to know that for the next show. But the reality is it's a business decision. So the reality is the attorney's trying to guard some kind of exposure that they think the association may have, but they're making a business decision that hurts the unit owners. So we all forget, and I do too, because these associations sometimes become so adverse to what appears to be the seller's best interest. These guys work for the sellers, and there's in the governance form, I think in the meetings and notices number 6, it says that if 20% of the unit owners petition the board to talk about something, they have to talk about it. So if you have a small association, if you have a 100-unit association and you get 20 of the unit owners to petition the board, they have to talk about that topic.
Yeah. I want to let everybody know too that the outline and the recording of the video is going to be emailed to all the attendees as well. So you will have these links that you can click on too as well, and that is a great resource.
Yeah, these little high points of the governance form are stuff that you guys can use. I use it. I mean, there's no secret. Law school was great, but law school doesn't teach you the law. Law school teaches you how to think. And so I'm happy to teach you guys the ways of the law school mind, because it just helps you get to the goal of, the goal quicker. I like to say it's 2.5 years, 3 years of law school boiled down into 30 minutes. All right, so pad split. Here's another important topic. If you guys don't know what this is, you need to know what pad split is. Morning, James. Pad split is going to make Airbnb look like, marijuana compared to crack. Pad split is a very, very big problem in Orlando. If you guys aren't familiar with it, don't feel bad. Pad split is room sharing in houses. So there's a whole body of law that governs Airbnb and bed counts and things like that. I have to wrap my head more around where those calculations come from. I've got a meeting I'm trying to have with the city of West Palm, because there's Florida law, there's Florida statutes, there's ordinances, and then there's other calculations that go into these Airbnb bed counts. And bed counts don't equal body counts, but pad split is along those same lines. If you're looking into, if you want to do some research on pad split, and you can see where it's starting to really become a problem is in Orlando. There's only a few pad split homes in West Palm Beach, but if you search pad split for available rooms in Orlando, they're everywhere. And the Orlando planning staff will tell you this is already becoming a huge problem. Anybody have any questions on pad split?
No, but I can chime in a little bit because I'm working on them on one and in Riviera Beach, and I know the pad split people. Like anything, right? Sometimes something too good becomes abusive. And to your point, I didn't know this about Orlando, but pad split themselves have had issues with local ordinances. And when they basically addressed it, they just simply said, you know, look, we're providing a service that you
Yeah.
cannot to your residents. You know, there are people who cannot afford to live here, and we're providing that service. And supposedly they back down every time. I don't know how many times this has happened, but that's what I've been told by the pad split people.
Yeah, so basically the way Airbnb, good point. The way Airbnb and pad split operate is they rely on the owner to research the laws and make representations to pad split or Airbnb as to the capacities of the homes and if it's in compliance with law and ordinance and zoning rules and things like that. And licensing, quite frankly. So whatever the owner tells pad split or Airbnb, Airbnb and pad split advertise. So if you don't know the rules and you don't know the laws, that's potentially problematic. It's not a matter of whether they'll advertise for you or not. It's whether or not you're actually telling them the proper information to advertise. Sorry about the noise outside, you guys. They're doing some construction
Oh,
outside.
we can
the
hear you
shop.
loud and clear, Jim. Yeah, I
Great.
mean, pad splits is disrupting the real estate, almost like what Uber did with taxis, right? So it's, you know, I mean, I think a lot of these municipalities and stuff are gonna, try to respond as best as they can. But as an investor, there's a lot of upside, obviously, of being able to rent out your property by the room. You know,
Well, and that's what's going on right now with Airbnb. I'm seeing some clients contacting me and saying Airbnb doesn't make us enough money anymore. Pad split does.
well, Airbnb got really high on their fees too, Jim. You know what I mean? They got really high on the percentage that they were taking as well.
I didn't realize that. What did it jump from?
I'm not sure what exactly the amounts, but I had clients too that were doing Airbnb. Then they switched over to, VRBO because the fees were less. So it's, it's a competition. I'm sure the same thing will happen with Pad Split, but from what I've heard from people that have used Pad Split, that it is a lot better return.
So what I'm trying to do is, and I'm working hard to schedule something with Palm Beach City planning staff, because the problem is you've got this complex overlay of laws. And if I can get an outline of the exact rules that govern these pad splits and the bed counts and body counts for Airbnbs, I'm happy to share it. But right now, if I were to explain what I know, it's way too confusing. I'm just going to tell you the way it is. It just doesn't look good right now. All right. SITS or NAR update. It is more important than ever to be a critical thinker in this business. You can no longer just be a follower. The days of just listening to anybody in this business are over. It doesn't matter who's telling you something, even your broker. You've got to be a critical thinker. If you never had a reason to never tune in again before, you certainly have a reason to never tune in again now. And what I'm about to tell you is confusing to me, but if you sit and you marinate on it, you're going to come to some conclusions. Just sit through this. We're going to talk about this more, and we're going to get to the good disclosure stuff in a minute, but we got to understand what's going on here. So there's a couple definitions that I think they're important to understand. Civil and criminal liability. Civil, the remedy is money. Criminal is a judge tells you you have to go to jail or you have to stop doing something. SITS or NAR is purely a civil lawsuit. The Department of Justice is both civil and criminal. And if you guys are old enough, think about O.J. Simpson. He was liable civilly, but he wasn't liable criminally. That's the big buildup for what I'm about to tell you. November 26th, the SITS or NAR judge approved the settlement practice rule changes. So up in that time period, whatever it was, July or August 17th up until November 26th, we were just going through the motions and we were hoping that the judge was going to sign off with no exceptions, and they did. However, 48 hours before the ruling, if you guys are familiar with this, just chime in if you guys have anything to say.
Yeah.
48 hours before the ruling, the DOJ filed a statement of interest, principally calling out two practice changes in the settlement: buyer's agreements and sellers offers of compensation out of the MLS. The big DOJ SITS or NAR settlement beefs were before buyers can see a home. So this was both, they believe that buyers agency agreements, the Department of Justice believes buyers agency agreements are a restraint on trade for the following reasons. Before buyers can see a home, they have to agree to a rate. just think about this stuff and then we'll kind of wrap it up. Before they can get a feeling for the quality of their agent, they have to name a price. And buyer's agent agreements are restrained on how brokers compete for buyers. These are some quotes from the statement of interest. It bears a close resemblance to prior restrictions among competitors that courts have found to violate antitrust laws. And the DOJ notes that an approval of the settlement does not prevent or restrain ongoing antitrust violations or remedies. Past violations or itself contemplates practices that fully comply with antitrust laws. That's from a Housing Wire article. That's all very confusing. We're going to break it down and make it more simple. The DOJ also took issue with buyers' agents' inability to get more commissions after a touring agreement is signed. If a buyer's agent, so this would be a touring agreement or BA.
Yeah.
If a buyer pays 3%, a buyer's agency is signed at 3%, and the seller is paying a bonus, buyer's agent can't get the bonus. They are calling this a restraint on trade. It ignores the fact that agents can't get, this is the problem that I have with it. It ignores the fact that the agents can't get the BAs amended, which they can. And I think I speak for all agents when I say, we'll live with what that limit on commissions versus getting sued by the DOJ because we can't get more money. In other words, I think we'll live with our current paradigm instead of having this ongoing exposure thing, as long as we can have it explained to us properly. Restrict some agents from making a business model. So that it also restricts some agents from making a business model where they want to show all the homes they can show, and then they're going to negotiate the commission afterwards. So if you walk into the theory is this: if you walk into an agent's office, the buyer's agent says, I want 3% or I won't show you anything. That's going to be an uphill for some people. Some people want to go out and they want to tour homes and get a feel for their agent. And then they're going to say, oh, 3%, we're happy to do that. From the DOJ's perspective, that's a restraint on trade. And I don't disagree. If you want to prove your value by showing people and then getting a better, stronger commission from them, that should be something that buyer's agents are allowed to do. It should not be prohibited. When you put it this way, it starts to make sense. But the problem I have is, when was the last time the DOJ looked out for agents? It's just been an inconsistent thing. So the other problem they had was offers of compensation off the MLS did not go far enough. It sounds like the DOJ would like to see all offers of seller compensation go away before a buyer's offer is made. To tell me that in and of itself sounds like a restraint of trade. Anytime you're saying to somebody, you have to do business a certain way, that sounds like a restraint on trade. In my mind, if you want to charge a person a fee before they show up in your office, or you want to tour properties with them and then set your fee, that should be the free market, and that's the way you want to work. Anytime you tell people that you're going to do something a certain way, anytime you say you can't put offers of compensation in the MLS, or you can't put offers of compensation in any other areas, that sounds like a restraint on trade. If you want to put a sign, I've said this since the beginning, if you want to put a sign outside your house that says, I lost my dog, $100 paid for any information leading to the where the dog can be, why should sellers not be allowed to do that? If sellers want to pay fees to have people tour their house and not even make a closing occur, why should they be restrained from doing that? My point is, any rules that we come up with are restraints on trade. Unrestrained trade, to me, sounds more like sellers can make offers of compensation anywhere and everywhere they want, including the MLS. If a seller on the MLS is offering 1 and the buyer insists the seller pay 3, seller can accept the offer or reject it, right? Under our old paradigm, it worked. If you met with your listing agent and the seller said, I only want to pay 1%, and the offer came in at 2 or 3 and the seller didn't want to step up, then you don't have a deal. Sounds to me like the old system may not have been as broken as we were made to believe.
I know.
Exactly what I was thinking. This is going full circle.
I cannot. Yeah, there you go. Jeff's a co-host now. I cannot believe we are having this conversation so close. And I'm sorry if I get so emotional about this thing. I'm so upset that this thing seems so ill-conceived. I cannot believe we're having this conversation so close in proximity to the rules we all, from what I can see, successfully rounded the corner on and we're actually executing on. Like, it has nothing to do with my pride, but I am so proud of our industry for operating the way we've operated in the face of all these changes. And now to potentially have this stuff thrown out, or we'll get into it more. What does all this mean? The DOJ reserves the right to continue antitrust proceedings against brokers and agents. Although the Sitzer-Nar settlement protects agents from more private party civil lawsuits, it does not protect against the DOJ civil and criminal action. Agents. So now agents have to make a choice. They don't have to make a choice. I took that word out. Agents have a choice. You either get buyer's agency agreements and stay compliant with Sitzer-Nar settlement, receive immunity under the settlement, but face potential liability to the DOJ, or don't get buyer's agency agreements, have certain exposure to other Sitzer-Nar copycat lawsuits, but not potentially have exposure to the DOJ. I don't want to make you, I'm not suggesting you decide right now. I'm just telling you the paradigm that appears to be evolving. NAR has to take a position. They have to advise their agents. I have a problem with a few troubling facts. The disclaimer on the bottom of each new realtor form, it all smells like they knew what was coming. To me, I'm not a conspiracy theorist, but maybe I am. But if you guys look at the new forms, every single form on the bottom, it says that this is not legally sufficient and shall not be relied on for legal significance. That smells to me. When was the last time you ever paid money for a legal form and it had a disclaimer like that on it? I really have a problem with NAR's pre-settlement statement that they did not want to gamble on its own existence on appeal and several more years of litigation. Who is NAR fighting for? Is NAR fighting for NAR's existence, or is NAR fighting for agents' existence? It almost makes it feel like condominium associations and homeowners. No, these associations nourish
Owners are the homeowner. I mean, it's a great analogy. Great analogy. It's true.
We're not supposed to be in opposition to NAR. NAR's survival means agent survival. And if agent survival means appealing and fighting the lawsuits because there's a breath of life in that court, you know, in that body, then we should be making that fight happen. And quite frankly, I'm going to say something that may not be, you know, win so much applause, but I have a real problem with the way NAR executives spend their money. And why wouldn't we be having those appeals instead of presidents that have club memberships in multiple states and, you know, for hundreds of thousands of dollars? How is it not, and here's another double entendre that I have a problem with. How is it not a restraint on trade for judges to authorize awards of a third plus as a standing rule in cases ahead of the litigation like Sitzer and NAR? But negotiating and agreeing on a buyer's agent commission on a case-by-case basis is potentially unlawful. The more you look at this stuff, the more twisted it is. Angela's like, oh my God, I cannot wrap my head around this early in the morning. Talk about a restraint on trade and consumers' inability to shop. If you're a plaintiff and you have a case, you already know what you're up against. Right? The fees are ridiculous. And those are approved by the court. All right, payout per homeowner. It looks like these are the problems I have with the whole dynamic. Payout per homeowner, it looks like it'll be under $1,000 a homeowner. But the attorneys are taking home hundreds of millions. Warren Buffett said a long time ago, you have to align the interests. What are the compelling interests here? Homeowners? Who has the compelling interest here? Attorneys. Once those alignments break, now you're not operating in the best interest of the homeowners. You're operating in the best interest of attorneys. I'm sorry, I'm an attorney. Did I say that out loud? NAR staff has been in the media for extravagant spending. I have a huge problem with that. And then one of the Sitzer NAR, Ketchmark said, there's still some more meat on the bone. He wanted to go after, referring to National Association of Realtors. It's not a matter of going after the meat if there's any meat on the bone. It's a matter of doing the right thing for the consumer, isn't it? What have I lost along the way?
Yeah. I think it's important too, as we're, going through this and this is evolving, is the public perception of us agents, right? Because obviously we have to educate our clients and because they do hear about this suit, they do hear of things, and we need to be cognizant of their perception of us and what's happening. You know what I mean? Because most of that, I think, was like, oh, the commission's going away, the 6% commission's going away, and then you have to kind of educate them. Well, it's not necessarily not. It's a free market, right? I mean, the people that are offering commissions, these sellers, to the buyer's agents, they might be selling the homes quicker, right? So it's a free market. We still have to make the offers, and we can adjust commissions on a case by case basis.
Well, we had people over for the holiday, and everybody knows that I educate agents in my family and friends, and they ask me, oh, I heard the commission structure changed. And the answer is no, it hasn't. The National Association, the first iteration of the National Association of Realtors was the bartenders and the barbers and the attorneys in town and the doctors all got together to talk about who was buying and selling houses. And there were no commissions set then, and there have been no commission rates set ever since. The commission rate didn't change. And one of the big problems is, I'll get to you in 1 second, Alex, is I think it's too short a window to look at, but when you look at the when you look at the rate of buyer's agent compensation post Sitzer NAR changes and pre Sitzer NAR changes, there's no change, right? It still sits at 2.6%. And again, I think the window that we're looking at is too short, but there's been no change so far. Alex, what do you got?
Yeah, actually, to that last point you made, Mike Del Prete out of Colorado is an analyst, and he, at this point, since August, has come up with did the math and said that agents are actually making more money now. So I was a little bit.
We can all agree that it doesn't appear that we've been taking part in a race to the bottom, and that is another big problem, right? Because if you're a judge looking at several $1 billion in settlement value, and you're trying to change this paradigm, but you're looking in the rearview mirror and saying, did we affect change? We sure spent a lot of money. A bunch of lawyers sure made a lot of money. Yep. But did we really get the change? Did we really implement the change we sought?
No.
Pregnant pause right there, man. I got a problem with it.
Money grab. Angela just posted a great link too in the chat about what you spoke about NAR, about what they were, some of their executives with spending and stuff like that has been brought up.
And that's, you can give a real knee jerk, right? And but there's lots of executives in big associations, but the reality is we're in the trenches right now, right? And love him or hate him, Elon Musk, he would sleep on the floor of the Model 3 factory when that production line was not working properly. We need trade association management that's willing to get in the trenches and take hard positions and not say these hedging things and do these things that appear in contrary to what our interests are. And I say we, right? I'm not a licensed agent, but I live the agent life because I talk to you guys every day. All right, it's important to remember this could all turn into nothing under Trump's administration. Real estate agents may not even be on DOJ's agenda. So everything we just talked about is unsettling as it is. You hate to look for a corner case, and this is certainly the DOJ's position today, but this could be a corner case because the admins that Trump's lining up to take over the DOJ, this could be as far, one of them talked about turning the DOJ into a museum.
I saw that in the news.
All right, main topic, here it is, disclosures, seller and agent rules. This is not going to be nearly as dramatic. This is bread and butter. This is how we make our living. If you do not remember anything from all my rambling, please remember the seller's agent rules, disclosures, and they're so easy to find. They're in the contract. People that I've been working with for my past 20 years as in private practice, they all know this stuff off the top of their head. If the agents know something, they are bound by the same rules, whether the seller knows of the issue or not. I get a call on that frequently. Well, the seller doesn't know, but I know. You're all bound by the same rules. The rules are easy to find and live in line 250 of the FAR bar as is. I just gave away my entire secret power right there because now you guys never need me. Now you can go right to the contract. You didn't know it was in there. And if somebody did know it was in there, I'm happy to see your hand go up. But if you didn't know it was in there, don't feel bad. Nobody knows that it is. So it's right here in line 250. Seller knows of no facts materially affecting value of real property which are not readily observable. So seller knows of no facts that materially affect value and are not readily observable. If any one of those elements is not present, then the seller doesn't have to disclose. So all those things have to be present for the seller to have to disclose. If any one of these things isn't present, and we'll go over some examples, then they do not have a duty to disclose. Again, that duty applies to agents and sellers. It can even be a duty on a buyer's agent side, just because you have knowledge of a specific problem with a property and you're on the buy side. Now you're under a duty to disclose. When all three conditions are met, sellers and agents have to disclose. You can replace seller with agent. Some relevant statutes agents ask about all the time when issues do not have to be disclosed. Florida statute 689, when occupants of real property have been diagnosed with AIDS, does that have to be disclosed? No. So there is a statute that says if people have AIDS, they do not have to, the seller is not under a duty to disclose. If the whole house was filled with people with AIDS, they do not have a duty to disclose. I just heard this morning on NPR that there was a big AIDS advancement in the treatment, but that's a side note. So, but the thing that's curious about this statute is, however, they did not mention other diseases, but they do not have a duty to disclose if there are AIDS. I think we can extrapolate by extension that it would apply to other diseases, but it does specifically mention AIDS.
Mm-hmm.
And the reason why I think it would apply to other diseases is for this reason here. Florida statute 689.25, when a property was or was suspected to have been the site of a homicide, suicide, or death, does that have to be disclosed? And the answer is no.
I have a funny story on that. I had about 12 years ago, I had a foreclosure that I was going to list, and I went into the house, and there was caution tape in the house, and there was actually a fire. You could tell there was a fire in the bathroom. And anyway, I got the listing. I'm getting ready to list it, and the neighbor comes over to me and tells me, "Hey, did you know that there was a homicide in the house?" And I said, "No." He goes, "Yeah, there was." And, knowing that I didn't have to disclose it, obviously they did the repairs and got the property up for sale. But guess what happened? Every time there was a showing, guess who came over and told the people, the agent, the neighbor, you know what I mean? So they're going to hear about it, right?
Why was the neighbor doing that? Wouldn't they want the property values high? You'd think if anything, the neighbor would want to conceal that.
I don't know.
Or the neighbor was trying to conspire to buy the property from the seller.
Could have been. Could have been, but we ended up selling it, got, pretty close to fair market value. And the people knew about the homicide, didn't bother them.
There was a double murder, parent murdered their two kids, and it was one of the roads at the extension of Belvedere, beyond Dixie. I can't remember what it is. It begins with a P, but regardless, there was a terrible crime there. And then there was another one in the south end further down. And both of those, although they weren't disclosed by the seller, they were real impactful on the value. I had a client a couple years ago a realtor called me a couple years ago, and they said, "Hey, I want you to nest a bunch of LLCs for this sale." And it was the property where the parents had adopted a child, and the adopted child was really creating a difficult living environment for the non-adopted kids. And so they were keeping the adopted kid living in a box in the garage for years.
Oh, goodness.
It was disgusting. Yeah, it was.
No, let's keep going here.
If some people might believe that death or the private, so you don't have to disclose, even if the buyer might believe that the death or on the property would materially affect the value. So we talked about if it materially affects value, then you're supposed to disclose it. But the statute says homicide or death is not a material impact the value. Not only may protect sellers from having disclosed, but may even protect when the sellers are directly asked. So the implication is if the buyer says, hey, was anybody ever killed on the property? Even if you're directly asked, you don't have to answer because of the statute. All right, here's some examples that'll stick with you for a lifetime. Johnson v. Davis is the old undisclosed leaking roof case. Inspections have come a long way since, but think back in the day in 1985 when we didn't have all the modern inspection tools we have now, infrared, moisture, all the things we can do. Johnson v. Davis was an old case that talks about when the seller didn't know that the buyer didn't know that the roof was leaking and there were in fact leaks. All right, so we've got the case of the rotted out shutter bolt, significant water loss, and the seller had no duty to disclose. So older people living in Jupiter had a 2-story, couple $1 million property. The shutters were retained with a bolt. The bolt passed through the wall, and there was a very small hole where the bolt had rotted out, and water was coming through the wall for years. The water rotted out the floor. The sellers conducted extensive loss mitigation, hired licensed mold remediators. I'm giving you guys the keys right now as to why they didn't have to disclose. Did impeccable restoration, put the property back together, and then they had what I call the book, the 3-part book. They had the pre-loss mold remediation plan, they did the remediation, and they had the post-loss lab reports and statement that everything was restored. So they have this book, and there's 3 parts to the book, and they executed perfectly. On the eve of closing, the buyer's attorney calls me and says, we're not closing because the sellers failed to disclose the water loss. And I said, we don't have to disclose it. And the question I put to you guys is, why didn't the seller have to disclose the water loss? Think of the 3-part test. The seller had knowledge. The defect was not readily observable because they had done such an impeccable job of restoring the property. So the only one left is, did it materially affect value? And I would tell you that the loss did not materially affect value because the restoration was done so perfectly, it failed the material value element, and so the seller was not under a duty to disclose. And I convinced the buyer's attorney of that, and we closed on time. Come to find out in the background, why do people hire lawyers? There's always some other thing going on, and they tell the lawyer, get me out of this somehow. The husband and the wife were fighting and they didn't want to close. But the reality is we closed and they couldn't use the disclosure failure as a reason not to. All right, case of the minor loss, unlicensed mold remediator and seller had a duty to disclose. True story in Lake Worth. People had a modest house. Inside the home, there was a window. In front of the window, there was a lamp and a small end table and a small carpet. When they contracted the property, the buyer walked through the property, everything looked great. On the walkthrough the day before closing, buyer walked the property, the table and the small carpet were gone, and the floor had a little buckling in it. The buyer contacted the inspector who did the original inspection, and the inspector showed up with a small camera, and they took the cover off the outlet. They took this optic camera and they stuck it in the wall, and it had a light. Ryan's smiling, he's seen this before. And they took a picture, they ran a video, and they took a video of the inside of the wall. Well, the wall was covered with mold, and it was a very small area, but the wall was covered with mold, and the reality was it was not restored properly. So in that situation, the seller had a duty to disclose. The seller had knowledge. It was a latent defect, not readily observable, but it did materially affect value because the seller employed a non-licensed mold remediator who simply pulled off the sheetrock and recovered the wall. All right, case of Mr. C's coming in next door. You guys will laugh at this one. Seller had no duty to disclose. So downtown, there's a condo, 801 South Olive. And for the last so many years, the lot next to 801 South Olive to the west has been vacant. The wall on South Olive that faces west has no windows on it. And for the last 9 months, there's been signs around the lot that say coming soon, coming soon, coming soon, and Mr. C's. So about 4 months ago, we have a client that closes on a condo. Not our client. We did a closing for a seller and buyer's agent. And so right after the closing, the buyer sends around a demand letter that says, you didn't tell me that there was a condo being built adjacent to my condo. It blocks my line of sight and diminishes the value of my condo. And I'm going to file a lawsuit unless you give me $110,000 for my losses that I'm going to have when I have to stay in another condo during the term of construction and for diminution in value. So did the seller have knowledge about Mr. C's coming? Yes. Did it materially affect value? Some people would say it does. Some people say it doesn't. Some people say it might even help the value in 801 South Olive. I think it's pretty readily accepted that when a condo is built next to another condo and the line of sight is cut off, and you can think of some extreme examples, you can understand why the more compelling argument might be that the value has been diminished. But number three, was it readily observable? So you have to have all three present. And the courts have answered on this many, many times, and those things are easily discoverable by a buyer doing a reasonable level of due diligence. In a 15-minute sitting with the planner on call for city staff, they will tell you what's coming in. Besides the fact that there were signs on the ground, besides the fact there was all the stuff going on before the building came out of the ground, and the banners and the placards, and all around that building for the last couple of years, there have been signs saying building coming soon. So where the buyer can do a reasonable level of due diligence and discover something, then the seller is not under a duty to disclose it, even if the seller has knowledge and it materially affects value. If the buyer can discover the problem with a reasonable level of due diligence, the seller is not under a duty to disclose.
I mean, did the buyer have a buyer's agent? I mean,
Well, that's another thing that was curious about that case. The buyer's agent was not named in the demand letter, and the buyer's agent and the buyer were friends. And the only person that they named was everybody else but the buyer's agent, the seller and the seller's agent. And then seller's agent had conversations with the buyer's agent prior to the closing about the development. The buyer wasn't there. And I guess the only time was a cash closing, out of state buyer, and the only time they came through the property was for the walkthrough or something. But regardless, there was lots of opportunity for anybody to figure out what was going on. All right, so here's a good one. We did a transaction for a buyer. The buyer bought a piece of property, very big piece of property with an expensive roof. And before the closing, there were no apparent signs of leak or water entry or things like that. So they go to closing, and a couple weeks after the closing, you can only imagine what happens. It rains and there are leaks. So in repainting and restoring, they find that there were leaks for a long time and painted over water stains in the ceiling. And then here's the kicker. Right before the closing, the seller hired a roofer and said, hey, I want you to fix the leaks. And the roofer told the seller was just a flipper. The roofer told the seller, hey, this roof is so old, it's exceeded its useful life and it doesn't need to be repaired, it must be replaced. So now the seller has knowledge, regardless of whether they've owned the place for the start. They know that the roof is expired, and the roof looked really good. And so that seller doesn't give that knowledge to the buyer, and then the closing happens and the roof leaks. Does the seller have a duty to disclose? And so since he painted over the roof and took steps to conceal it and did not disclose it, we won a judgment for the buyer for a very expensive roof. And what happens is people say, agents tell me all the time, how do they, and sellers tell me all the time, how do they know what I know? And so what happens is a buyer comes to our office, and the first thing we do is we tell them, get a letter of denial from your insurance agent. So now the insurance won't cover it. And the second thing we do is they engage us to do a little bit of low-level discovery, and we ask the seller who worked on the property for the past 90 days or 120 days, whatever the window is, or who's ever advised you on this property, or on the roof more specifically. And so the seller sends us a list of people who advised them on the roof or worked on the roof or whatever. And then we send to those parties a document called a request for admission. And we say to the roofer on that list that the seller told us looked at the roof, did you ever tell the seller that this roof needed to be replaced? It's exceeded its useful life and things like that. And so that's how easily we can figure out what people know, because no roofer is ever going to take a dive for a seller. And so the roofer responds, yeah, I told the seller it needed a new roof. And there you go. There's the hangman's noose. So when you hear sellers say, I'm just going to fire you, Mr. or Mrs. Listing Agent, and go hire a new listing agent, it's easy for buyers to figure out what sellers know, and that doesn't get the seller over the hurdle of having to deal with the issue. We're going to go over that in a little bit more in a minute. The case of the cracked floor, heavy carpet, big dining room table, seller had a duty to disclose. So at the contract signing, there was a massive dining room table, 10 seats around the dining room table, heavy carpet underneath it, big glass top table. No, the inspector did not lift the carpet or move the table. At the walkthrough before the closing, there was a massive crack in the floor revealing excessive settling. Everybody's seen a crack in a floor, but this was evidently a crack with an offset and some kind of leveling compound to level it all out. And so because these were not readily observable, agents call me all the time, how far do you have to go? There is destructive testing allowed in the contract. A buyer can damage the property in their analysis of the property. They can cut holes. They do have to restore the property if they don't close, and sellers have the right to sit on deposits. So just because a buyer cancels doesn't mean you're getting your money back right away. I'm going to digress for a minute. Just because
That's a whole nother show, Jim.
Huh?
So we could do a whole show on that one. But yeah, no,
Yeah,
they
just
call the
because a
deposit.
buyer cancels doesn't mean the seller has to give the money back. The seller has a right to inspect the property. It's in the contract, and take a look at the damage and restore the property, and then refund the money after the property's been restored. That's only if the buyer's done destructive testing. But I have had sellers sit on deposits for a while till they could re-inspect the properties and not give their monies back immediately. But in this situation, the seller knew of the crack in the floor. They leveled the floor with some levelers so you couldn't feel the crack through the carpet. And then, again, they put the dining room table. Not that they wouldn't have put the dining room table there, but it was all leveled over. I think it was a terrazzo floor. And so the seller had a duty to disclose, because it was not, the seller had knowledge, it materially affected value, but it was not readily observable. Again, all three elements have to be present. If they are, the seller has to disclose. And then we have the case of the estate, the elevated floor, makeshift repairs, and sealed walls and floors. So the seller had a duty to disclose. The seller was an estate. The seller had a contractor make all kinds of repairs. The contractor made substandard repairs. The floor, it was an elevated floor property, a huge property out in Jupiter Farms. They did substandard repairs below the floor and substandard repairs inside the walls, and they sealed the walls and closed up the floor. The buyer couldn't discover this stuff during the inspections. And then after a couple of years of litigation, the seller was liable, even if they were in a state and they didn't know what the state of the repairs was. The seller was liable because the contractor made the shoddy repairs, and the seller could have sued the contractor as well, but the seller was responsible to the buyer. Does that make sense, you guys? It was not readily observable, it materially affect value, and the seller didn't necessarily have knowledge, but the judge said that they imputed knowledge because they hired the contractor. All right.
I have a question.
Yep.
Debbie Quaid, Severa Real Estate, had a listing. My seller's attorney refused to let the seller provide the 3-page, 4-page seller's disclosure stating that it was already in the contract, which you pointed out to us earlier. So apparently, since he's a lawyer, this is allowed. You do not have to give the seller's disclosure several pages, but if we want it, we have to put a request in the contract.
Well, so a seller's disclosure is a negotiated thing in Florida. In some states, it's mandatory. California, you have to give one. But in Florida, if the seller doesn't want to give it, it's just like a seller today not wanting to pay commissions. They don't have to give it. And if the buyer doesn't like that answer, they don't have to buy. But the attorney's correct from the perspective that they don't have to give it. And there are lots of brokerages that have policies against and for seller's disclosures in Florida. But the most important thing to remember is that it's just another negotiated for element, just like a purchase price or an inspection period.
But if you put the wrong answer, it can really bite you later. And I've seen it. Yeah. Okay.
What do we always talk about when we talk about writing addendums and little additions to our contracts and additional terms? You want to say in as few words possible the thing you want to accomplish. Seller's addendums or seller's disclosures are like writing a book about things that you just are an encyclopedia for lawyers to pick apart later. And I don't, this isn't a down on lawyer. I'm a lawyer. This isn't a down on lawyers show, but that's how a lot of lawyers make their living. And seller's disclosures feed those fires. When you're practicing from a practical perspective, on the seller side, tell your sellers firing the listing agent does not make seller's duty to disclose go away. I get a call all the time from listing agents and they say the seller just wants to fire me because they say they don't have to tell this, if we get another listing agent, they don't have to disclose it. Wrong. That doesn't go away. On the buy side, you can send a copy of the damaging report to the seller. If you want to do something that's, I won't say unethical, but you get a report, you send a copy of it to the seller. Guess what? Now the seller's on written notice. So they can't ignore that if they don't negotiate with you and they think they're going to find another buyer. Now they're on notice and they must disclose this to future buyers. So why not deal with us now? These are tricks. They're tools as buyers and sellers agents we can use to keep the deals together when sellers and buyers sign agreements they don't read and they don't understand the laws. Our knowledge of the laws are our tools, and this is how we make transactions happen. Go ahead, Stephen.
Hear it.
You got the floor, Stephen?
Yeah, I asked him to unmute. There you go.
All right. We'll come back to you, Stephen. Tell sellers it's cheap and easy for buyers to figure out what sellers know. That goes back to the point where we were talking about buyers being able to, for under $2,500, $3,000, buyers can hire an attorney who can figure out what the sellers know. And I hear it from agents all the time. How do they know what sellers know? Sellers will tell me, how do they know what I know? It's so easy to figure that out. Looks like you're unmuted, Stephen. What's up?
Okay, so 2 things. I know you send out these recordings each day. Where or how do I find the subject matter to search for it? Because I didn't pull it up the very same day and now it's somewhere buried.
It takes us a couple days to get them out, but they live at the top of New Path Title. So if you click on here under Realtor Resources, you have master classes and registration.
And the outline.
Okay.
And then you're going to click there and you're going to get a whole list and you can click on this stuff and you can get the outlines and you can get the.
All right, I'm looking at it on a mobile phone, so I will.
Yeah, it's
try
a
to
little
remember.
easier on a PC. There's a lot there. I'm not really sure if it looks good, mobile friendly. That's something I'll probably have to talk to our web people about. But the fact that you want to get this stuff after the show makes me happy.
I mean, there's a lot of stuff there, a lot of their stuff from past shows too.
Yeah, we got all the shows you've ever done up there. All right, you
Super
guys.
valuable. Okay, I had the other point.
Oh, I'm sorry.
It was, going back to that, I had a double murder suicide in the house. And definitely years ago was told no need to disclose. And the reason given is that it's public knowledge. It was all over newspapers and
What year
neighbors
was that
knew.
case? What year
Sorry?
was that? What year was that? I mean, here's the reality, right?
Oh gosh, 20 or more years ago.
This statute's been around for a while. I forget about it. There's so many rules that impact our lives. There's no way agents can remember all this stuff. And a lot of times lawyers will give statements about rules where there's a more precise rule that controls the topic. So in the situation you're talking about, if it was after the statute was enacted, which has been a while, then the best answer is you don't have to disclose, not because it's general knowledge, because it's precluded by the statute.
Thank you for clarifying.
Absolutely.
Domenico asked, can a seller refuse to review a buyer's inspection report and still claim they do not know?
Can
a seller refuse to review, let's say the buyer does the
no, if you
inspection?
email it to them and whether they actually look at it or not, if you email it to them, then they're not allowed, then they can't claim they did not know the contents of the report.
So you have a receipt that you emailed them the report, maybe even put a highlight in the email saying, hey, per the report, page this, it says this, send them a report, they have knowledge,
It's kind of like when we talked about our condominium minutes and agendas, when you're on the buy side or the sell side, and part of the contract says that there were no special assessments contemplated in the meeting minutes or agenda a year prior to the sale. Are you going to look through every single point of that stuff and look for it? No, you're just going to send it to the buyer. Why? Because now they're on notice. If it's in there, they know it, whether they read it or not. Same thing applies here. If you have a damaging report and you're a buyer's agent and you send it to the seller's agent, the seller's agent is under a duty to show it to the seller. And B, even if they don't read it, neither of them, they're still bound by the defects revealed in that report. So if that report says that there's a huge crack in the slab underneath the dining room table and the heavy carpet and all the glass chairs that potentially has significant financial impact to the property, needs to be investigated further, and this is a true case, and the seller calls me and says, I'm just going to fire the agent and sell it to somebody else. No, once the seller is on notice of that stuff, not the fact that it's cracked, the seller was on notice that it was cracked because they covered it up. What the seller didn't know that the report revealed was that it had significant financial impact. And in this particular report, they gave damage estimates of between, I don't remember what it was, $10,000 and $20,000 or something. Some inspections give remedial cost, repair costs, some don't. Stephen, did you have another question?
I believe when whoever sends the report, buyer's agent, somebody receives it, I believe that you have to keep that report and disclose that to any future buyers if the deal doesn't go through. Is that right?
Yep, that was the point we made earlier. So once a seller has knowledge, that's the global walkaway from this discussion is, this element of the discussion is, once the seller has knowledge, they've received the report, whether they've read it or not, a court deems they have knowledge of those issues. So even if you haven't read it, the court would say you received it in an email, you're on notice, whether you read it or not is no excuse. All right. This is a biggie, you guys. I hate to drop, I hate to say bombs, but anyways. So after October 1st, there's a new mandatory flood disclosure. And I was going over Tajay, the contracts with Tajay before the show, and he said we're seeing it in some of them, we're not seeing it in all of them. Maybe they're sitting in your files and they're not getting to us. But we went over a few files and only a couple of them had these disclosures. Kudos to the agents that are doing this. They're in the podcast today. And failing to include this form as a material default by seller, the burden is on the seller to prepare, sign, and provide it. In the statute, it says seller shall. When it uses words like shall, And it specifically says, it doesn't say every transaction shall have this form. It says seller shall provide this form. So now there's a duty on seller's agents. Buyer's agents, doesn't mean you can be asleep at the wheel on this. Why? Because if your buyers get sideways and they're looking for an attorney to screw the, to undo the deal, they're going to say, well, we never got our mandatory disclosure. You want to shore up your commission? How do you shore up your commission, buyer side? Make sure all the forms are in the file. So this is a residential property. At the latest, when the contract is signed, the disclosure form has to be completed. The thing that's confusing about this form is in my forms library, it's in the FAR library, not the FAR bar library. It's in the FAR library. And it's at the bottom under miscellaneous forms. So I'm going to tell you to mix forms, but be careful. Don't mix other forms. This is the one form I can tell you is safe to mix. What I mean by mixing, so there's a FAR as is FAR bar library and a FAR library. This is a FAR form, but you're going to use it with the FAR bar purchase and sale agreement. Brian, you're wrinkling your brow. Is there something I don't know?
Well, I'm just looking here on form simplicity, where it is, the flood.
And at the very bottom, it says FD1 revision 924-2024 Association of Realtors. That's how you
I mean,
know.
this is important, I mean, I just took a listing, Jim, and I didn't do this.
I hate to say this at the
I
end
know.
of the show because we had all this, I get everybody's attention at the beginning of the show, but this is a hugie. It's required by law. It's limited to sellers, does not apply to previous owners. So if a previous owner got FEMA money, it doesn't apply to them. It just applies to the seller. It defines what flood is. It's not a burst of a water heater, and it appears to apply to condominiums. It certainly applies if a seller got the FEMA money. We'll go over the form in a second. But what if the association received the FEMA money and the owner and the seller did not directly? I don't know what the answer is. I'll figure that out.
So,
And it
so in
also
form simplicity, just I'll add in form simplicity, it's under the Florida library. So it's not under the beaches. It's not under Broward. It's under Florida. The Florida
And then
library.
it goes on, it doesn't define what residential property is. And so there are going to be people who might argue, it's an Airbnb, it's not residential, it's commercial or something like that, or it's two family. Anyways, this is the flood disclosure. Florida statute 689 requires seller to complete and provide a flood disclosure to a purchaser of residential property at or before the time the sales contract is executed. It says right there, this isn't a statement out of the statute. It paraphrases a statute, but it says right there in the first line, requires seller complete and provide.
Yep.
Then there's a bunch of election boxes about whether they've had insurance claims related to flood, whether they've had FEMA money and they've received FEMA money. And then the part I like best is, for the purpose of this disclosure, I'm looking at the last section, number 3. For the purpose of this disclosure, the term flooding means a general or temporary condition of partial or complete inundation of the property caused by any of the following. A flood doesn't mean the whole place went underwater, just part of it could have gone underwater. The overflow of inland tidal waters, the unusual and rapid accumulation of runoff water, or sustained periods of standing water resulting from rainfall. So now it's not the water heater, it's not we had a hose bib at a house the other day burst and filled the house with water. It's none of those things. Anybody have any questions on that? Pretty straightforward.
So I have somebody who has standing water twice in an area in the yard for the 100-year rains in Hollywood, Florida. However, she didn't make any claims. She did disclose it on the seller's disclosure, but on this flood disclosure, she only checked, she hasn't filed a claim, has not received federal assistance, but it doesn't address whether any of those items ever happened, correct?
Correct. This just says, flooded homeowners insurance policies do not include coverage for damage resulting from floods. So this is what you're supposed to tell. This is the disclosure part. Seller has or has not filed a claim for an insurance provider relating to flood damage to the property, including but not limited to a claim with the National Flood Insurance Program. seller has or has not received FEMA assistance for flood damage to the property, including but not limited to assistance from FEMA. For the purpose of the disclosure, so you're not having to delve whether there is standing water in the backyard in a 100-year flood event, but you're having to say whether insurance claims have been filed, rejected or not, or whether the seller has received FEMA money. All right, the next disclosure as of July 1st, we're going to make this easy. We're going to make an easy one for you today. Pretty simple, and it's incorporated in the new form, spells out how unit owners could be responsible for fees on common elements not within their condominium. And it's already in the condo form. Here is the form, the section of the relevant form, and it talks about nested condominiums and parties being liable, buyers being liable, owners being liable for condominium fees outside the definition of their immediate condominium. So you have homeowners associations that have nested condominiums, and the buyers could be liable for a portion of all the fees. And they should also be on notice, according to the statute, that those elements are not within their condominium. But it's an easy one because it's already in the condo disclosure. But you should be familiar with what it is. It's right in the section below the milestone inspections. You should be familiar with the area that it governs. All right, we're at 11:09. I'm sorry I kept you guys so long. I paused on the sits or NAR stuff longer than I wanted, but I think it's important. Bonus topic on how to control title when you guys represent the buyers or you're in another county where the other side chooses title. If you like the way we work and you like the content that I provide, just choose new path title in paragraph 20 and don't shift who pays for title. Don't make it a hill to die on, but if you can get the other side to choose us and they pay, more power to you, and I'd love to work with you guys on your deals. Oh, and this is one I say every week. The party who chooses title is by custom, not by law. If somebody can tell me how that law evolved or that custom evolved, I would be more than happy to escort you solo or with my company to a dinner place of your choice. And you can text me 24/7 for any support you guys need. All right, that's it.
Wow, Jim. Well, thank you. I mean, that was some in-depth stuff in there. I mean, some really good nuggets in there too for us agents. I mean, especially now this flood disclosure, just myself, make sure I get that signed ASAP. Would it be smart too to even put it in the attached documents, right, on the MLS?
Yeah, and that's a really good point. Get it done right up front. Just another thing, but if you have your established forms that you're going to submit and you're on the listing side, and put it in your checklist if you're on the buy side, get it right up front. Get the seller to sign it at right after the listing. I hate to say at the listing, you want to get in and out and get the listing signed as quick as possible, but get your TC to follow up, or you follow up and get it done.
Awesome, Jim. Well, thanks everybody for attending. As I said, check out RealTrade. You can just Google RealTrade or go to realtrade.io. You can make a free profile, get free leads, get connected with awesome service providers like Jim on this call, like Jeff Stewart. They're on this call. You can message in there as well. Also, definitely check out New Path Title. I love using them for all my sales. That I have the listings, and of course tried shifted over to now on the buyer's side, but his awesome closing software, Title Leap, it's like a free contract coordinator. Love using that. And two, I will say this, take advantage of Jim's free service, Title Advance. Title Advance is a free service that he's offering to us agents where going into a listing if there's any title issues, and you won't waste your time, you won't waste money. I mean, I've had this actually, Title Advance has saved me in a couple deals because the deal was too thin to close. They would have had to bring money to the table. They didn't even realize there was a second lien on the property. They thought it had gone away from some kind of different program that they were offering. Like, no, you guys are gonna have to pay this. I'm just saying those are type of things that Title Advance actually does for you. And of course, if you're buying, it's nice to know if there's any title issues on the property as a buyer's agent as well.
Ryan, that's a really good point. So there are second liens. They're forbearance. So when you got a forbearance during COVID, when a borrower got a forbearance during COVID, sometimes it was tacked onto the principal loan and you just had one mortgage. But we are seeing more frequently that these these HUD forbearances where HUD actually assumed the forbearance responsibility, they file a second lien. So the property has two mortgages, and if you interview the seller at the listing appointment, they're only going to tell you it has one. But there's a second lien, and that second lien, we just saw one the other day. If Tajay's on, he'll remember the numbers, but I think it was like a 160 first mortgage and a 60,000 second, or 260 first and a $60,000 second. So these second lien foreclosures that sellers have no idea about, Title Advance will reveal those.
Awesome. Save you a lot of time and effort. By literally like 5 minutes of work, guys. 5 minutes of work. So
don't forget our closing calculator has been updated. Can you see this, Ryan?
yep.
So if you go to the top of the website, you got a closing cost calculator symbol. If you're on the buy side or the sales side, you have all kinds of new boxes that you can input the intricate transactions and dollar values that under the new settlement rules from our sitzer that you guys have to input. So now we have on the seller side, you can have a buyer's realtor commission, the seller's concession to buyer, and all the little things that they may or may not want to include in the deal. You can do it live while you're sitting at the listing, or you can do it live while you're sitting with your buyers at the signing of the BA.
Just show them one last time too on a new Pat title where they can get the outline too, just for all the past shows, Jim.
All right. So you go to newpathtitle.com. And you've got a button at the top, Realtor Resources,
Yep.
and then there's a button here for masterclass registration, videos, and outlines. And then underneath that, here's all our most recent shows, and then here's all our past shows.
Mm-hmm.
So here's the one that I was looking at. We talked about in October, where we were talking about the new forms that were coming down the pike before they were released. I think it was August. And then today's show, we talked about the new forms that were released that included the flood disclosure and the condo disclosure. You guys, I feel for you. And I'm not being, in all sincerity, this is the list of forms that have been published in the last year. These are all the changes and revisions. As long as I've been practicing, the list of changes and new forms maybe was 4 or 5 lines. Maybe. Now it's just ridiculous.
Every month.
And with these, and look at, they're all, within the last year, and then it goes back a little further, but there's never been the level of change that we've been witnessing. And the concept that we may even be reverting or going back to, or don't even think about it, but it's just know that it's out there. And if you want to talk to your brokers about, the Department of Justice's statement of interest, see what your broker has to say. I'd love to have you bring it to the podcast. Don't forget to join us on December 5th at 7 o'clock at Sushi Joe on the 2nd floor. That place is dope.
It is. I shared a link to that too in the comments here too as well. It's copied.
Thanks, Ryan.
Yep.
All right. Have a great day, you guys. It's 11:15. I'm sorry I kept you a lot longer than I wanted.
Thanks, Jim. Appreciate it. Thank you, everybody. Till next time.
See ya.